Mediation can be a wonderful tool to help parties resolve their claims without the risk, expense, and energy that's required to prosecute and/or defend a case at a full-blown trial. Mediation is a process where each side agrees to use a neutral third party who's called a mediator. The parties agree on a date, time, and location, as well as who the mediator will be. Sometimes mediation is ordered by the court, and sometimes it's voluntarily agreed to by the parties. I meet with my clients for at least 1 hour before any mediation to go over the specific facts and issues of their case. With some complex cases, the mediation meeting may even be longer. Once we arrive at the mediation, the mediator will introduce himself to all the parties and make sure that everyone who is attending the mediation knows who all the other people attending are and what their role is in the case. I've attended some mediations where some people did not want to identify themselves or the parties that they were representing. This occasionally happens when we have an umbrella or an excess insurance policy that may be called in to pay the damages in the case if the case is not resolved at mediation and we obtain a verdict in excess of the policy limits at trial. However, in most instances, everyone readily discloses why they're there and what interest they have in the case. The mediator will pass around a document in which every person attending the mediation will sign, agreeing to keep the discussions and negotiations that take place at the mediation confidential. Mediations are confidential, and what this means is that each side can, for the purpose of trying to settle the case, agree or admit to things that they may not agree to or admit at trial. And because mediation is confidential, each side can relax and not worry about saying something that will be used against them at trial. For example, the defense may say that they are not contesting fault at mediation, but they might fight fault at trial. Or they may offer a settlement figure, or you may make a settlement offer, and if the case is not settled, neither side can suggest to the judge or the jury that at mediation one side was willing to settle the case for a certain amount. When I'm selecting a mediator, I look for an experienced lawyer who's handled this type of case in the past. I found that former trial lawyers and judges are excellent mediators because they have a good grasp on the issues that will be presented at mediation, as well as a good understanding of the costs and risks associated with litigation. Most mediators in Florida are certified by the Florida Bar, and the mediator's role at the mediation is to help both sides focus on the issues and help the parties reach an agreement. They try and reduce the negative feelings and points of controversies between the parties. They will suggest that the parties should openly discuss the issues in their case in such a way that resolution might be reached. They will also convey the risk of having a jury of strangers and a judge making the decision that will affect all of the parties if a settlement is not reached. It's important to remember that a mediator is not permitted to give legal advice, nor do they rule on or make any decisions for the parties. Mediations have a pretty high success rate. In my experience, about half of the mediations result in a full or partial settlement of the case. However, I have found that some insurance companies have started using mediation as a tool to try and drive a wedge between the plaintiff's lawyer and his client. They do this by making ridiculously low offers to the plaintiffs. Prior to going to the mediation, some lawyers will suggest to their client that mediation will be a positive experience in which the insurance company will come in good faith and offer reasonable amounts of money to settle the case. So when that doesn't happen, the client begins to doubt their attorney's skill. This is a cheap trick that insurance companies are using to create friction between an attorney and his client. However, the insurance companies do not use this tactic with aggressive trial lawyers they know have the skill, experience, and resources to go all the way to trial. So attorneys who may not be prepared to go to trial will unfortunately cave under this insurance tactic and pressure their client to settle the case for less than it's worth and take the low offer made by the insurance company. Now, once all the parties arrive at the mediation and the mediator has introduced everyone and everyone has signed the confidentiality agreement, the mediator usually turns to the plaintiff's lawyer and asks that he or she make their opening statement. In some cases, the opening statement can be as short as 2 or 3 minutes. In other cases, it may be as long as 2 or 3 hours with exhibits such as medical records, video clips of depositions, photographs, and charts. The plaintiff is trying to help the mediator as well as the insurance claims adjuster and the defense attorney to understand what a jury will likely see in the event the matter is not resolved at mediation. After the plaintiff's lawyer has made his opening statement, the mediator will then allow the defense attorney to present their side of the case. Typically, the defense attorney will address my client directly and say something like this: "This is my only opportunity to speak to you, and I have a job to do, and I'm going to say things you won't like. However, you need to listen to what I'm about to say, because if we're unable to resolve this case today, you will be facing a jury who will hear the same type of information, potentially to use this to rule against you." Then the defense attorney will go through their list of why they think they've evaluated your case for a very low settlement figure. And I always suggest to my clients that they listen carefully and keep a poker face and not react to the defense lawyer's comments. In other words, do not show or express emotions or make faces while the defense attorney is talking. If you do react, they may perceive that you are scared to go to trial and that you might take a low settlement offer, or that you are angry and at trial you won't make a good witness. Keep in mind that this is likely the very first time the insurance adjuster has ever met or seen you. So their impression of you goes a long way in their evaluation of how much money to offer you. This is also why dressing appropriately, like you're going to church or to an interview, and holding back your emotions may increase your settlement. I also tell my clients that at every mediation, we will learn something. As a plaintiff's lawyer, I find mediations are extremely valuable places to learn from the defense how they view the case. So in the event that we cannot settle the case at mediation, I have a better idea of what they're going to focus on at trial. Now, once the defense lawyer has finished their opening statement, the mediator will usually break the parties into 2 separate rooms, and the mediator will shuttle back and forth, carrying information from one side to the other. A good mediator will address the weaknesses of each side, suggest that they might want to make some compromises, and do their best to explain to the plaintiff why they should reduce their demand, and at the same time explain to the defense why they should increase their offer. The mediator will ask questions that will prompt each side to continue to reevaluate their position. And a highly skilled mediator will often help parties that felt like they would never reach a compromise somehow reach a compromise and settle the case. If and when a settlement is reached, the parties will sign a written agreement memorializing the settlement terms and agreement. The attorneys will then prepare the necessary paperwork to file with the court so that your claim is paid, a release will be signed, and the matter is resolved. If a settlement isn't obtained at mediation, sometimes the settlement negotiations will continue, and many cases are resolved closer to trial. I'm glad to say that mediation, in my experience, is a very useful tool that has brought about many great settlements of cases that sometimes even I didn't think would get resolved. I hope you found this information helpful, and if you have any additional questions that you would like to ask about mediations, please call me. And thank you for watching my video.